going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hopefully you guys are about to have a great day. It's still morning. Anyways, I've got a very interesting day. So a police officer gets fired for lying all the time. He was lying on affidavit. He was lying in court. He was lying under oath. So this attorney's reopening some cases. A lot of cases were reopened, and this is one of them. It's interesting. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
506. Your Honor, I filed a 3.850 motion just for the court. The state had responded that we did not state in the motion the relief requested. So what I did is I amended that motion. I had talked to Mr. Sullivan when that come back, and we had filed that this morning, just requesting the relief that we wanted so that we could check all the boxes. Your Honor, I'm sure you've read the motion. I'd like to just go ahead, and Mr. Shepard is here. I can go ahead and question him and make this pretty quick.
Okay. And Madam Clerk, if you'll swear Mr. Shepard in.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
You're Rusty Shepard, an attorney here in Bay County, correct?
Yes, sir.
And you represented Mr. Sanders in this case that we're here for today on a 3850. I believe it was a trafficking case.
Yes, sir.
Okay. Did you file a motion to suppress physical evidence in that case?
I did.
And was that heard before Judge Clark?
Yes, sir.
Was the basis of that motion that the confidential informant was not disclosed, thus none of the information could be corroborated, had not been established as a credible informant?
Yes.
Okay. And so basically this boiled down to Investigator Williams' credibility before the court.
Absolutely.
Okay. Was Investigator Williams the only one that testified at that hearing?
That is my recollection.
Okay.
We would have loved for the confidential informant to be there, but under the rules, we couldn't get to the confidential informant.
Okay. And was the motion denied?
It was.
Do you remember the court's holding on that?
I don't remember. I do not recall specifically. I just remember it was denied.
Basically, the judge had to determine the veracity, reliability, and basis of knowledge had been established by the CI's prior work, and then the judge denied that.
Correct. And
denied your motion.
Yes. Based upon Investigator Williams' testimony at the hearing. I think he had said that there were several cases that he had made. They had led to arrests. They were currently under prosecution. My recollection is that, he was the only one who testified at the hearing. So obviously it was based on his credibility.
Okay. And based on this denial, Mr. Sanders had to basically accept a plea on this case.
Correct.
Okay. With Investigator Williams, did this involve some type of internal investigation and any sanctioning on him?
I mean, we later found that Investigator Williams is, his credibility is zero. I mean, he's been fired from the sheriff's office.
Objection, Your Honor.
What's the objection?
His opinion about his credibility.
I'm gonna overrule the objection.
He has none. He has no credibility. He lied. I've seen him lie in court. He's perjured himself.
Objection,
he has no credibility.
Was this unknown to you?
Oh man, that prosecutor is really trying to get no credibility. I mean, yeah, they filed a motion to get this case either reopened or just outright dismissed because of this lying officer. And yeah, the guy they're interviewing right now, if you didn't hear, this is the defense attorney that defended this guy before, and yeah, you can tell he's not happy.
You at the time of Mr. Sanders' case, this internal investigation?
Unfortunately, yes.
Okay. Um, have you had any other cases come back to court because of Investigator Williams' problems?
So two of our clients, Mr. Sanders somehow, I don't know that we ever found out who the confidential informant was in Mr. Sanders' case. Otherwise, there would have been three. But two of ours came back. One was released from jail. The other was his sentence was vacated. He came back and pled to time served. And there were, I believe, seven clients or seven individuals who were represented by the public defender's office who also came back. So I'm not sure how Mr. Sanders got lost in the shuffle. My apologies to Mr. Sanders. Certainly, he doesn't, wish we would have known about the investigator's credibility at the time.
Had you known about Investigator Williams' issues, would that have directly impacted Mr. Sanders' case and how you represented him?
Absolutely. Would have allowed me? Yes. Yes, sir. Absolutely.
Would it affected your advice as to whether he should accept a plea or not?
Absolutely. Yes, sir.
Okay. Would it affected your ways of how you questioned Investigator Williams at the motion hearing?
Absolutely.
And the motion to suppress?
How I argued it? Absolutely.
And basically as to your whole case with Mr. Sanders, correct?
It was based on Investigator Williams.
Did you ever learn who the confidential informant was in Mr. Sanders' case?
I did not. And in fact, actually, to this day, I'm not sure. Oh, I mean, you would know that, but.
And if you recall, do you remember Mr. Sanders' plea that he had to take in this case?
It was 1 to prison time, Department of Corrections.
Okay. Your Honor, that's all the questions I have for Mr.
Yes, Your Honor. Mr. Shepard, let's talk about some of those other cases first. You represented Amber Fry, correctly?
Yes.
Correct. And in your representation of Amber Fry, you came across some information that in that case there is a confidential informant that was not properly registered by Investigator Williams, correct?
Yes. I should preface that it was my firm and we all worked together on it. So, obviously, as you're well aware, Mr. Gunter. Yes, but Mr. Gunter was lead on that. Yes.
Yes, your office, and through the course of that investigation, your office determined or was able to figure out that particular confidential informant was involved in 10 cases, correct?
I do not recall. My recollection was 9.
Okay. 9 or 10.
Again, that would be a question for Mr. Gunter and Mr. Sullivan.
And in fact, you currently represent that particular confidential informant, do you not?
My firm does, yes. Well, it represents her, yes.
That particular confidential informant that was not properly registered by Investigator Williams was not the confidential informant that was involved in Mr. Sanders' case, correct?
I do not know that.
Well, you would
know that, I would think.
Your office figured out the 10 cases that confidential informant was involved in, correct?
We figured that would be a question for Mr. Gunter. I don't know the answer to that. I'm not trying to be evasive here, but I know that there were 9 that we were able to get their sentences vacated.
After your office
Hold on, y'all can't talk over each other.
After your office figured it out, you personally called me to your office to have lunch to present that information to me. Did you not?
Yes, sir, I did. Mm-hmm. And I just don't remember the number, Mr. Sullivan. I apologize.
And I'm not hung up on the number, but okay. You presented the information of all of the cases that confidential informant was to me and my office at that time. Did you not?
That is my recollection. Yes, sir. Mm-hmm. Yes.
And Mr. Sanders was not one of those. And Mr. Sanders was not one of those cases.
I remember there being 9, but I remember we had gone through and figured out everyone that particular confidential informant was involved in.
And Mr. Sanders was not one of those cases.
I do not believe so.
And ultimately, those cases that that particular confidential informant was involved in, all of those sentences got vacated.
That I believe so, to the best of my knowledge.
I've got no further questions, Your Honor.
You redirect?
Mr. Shepard, knowledge of these credibility issues with Investigator Williams would have impacted Mr. Sanders' case and how you represented him, wouldn't it?
Absolutely. So I think the important thing here to realize is that Investigator Williams.
Objection, Judge, non-responsive.
Sustained.
That's fine, Mr. Shepard. That's all the questions I have, Judge.
All right.
All right. So what do you guys think? Is this poor defendant in jail because of this officer lied, or what else? This is really good. I enjoy these type of cases. Shitty officers, though. Pardon my language. I'm sorry.
Mr. Shepard, be excused.
Yes, Your Honor.
Or you may go about your day.
Thank you, Your Honor. Appreciate you.
Yes, sir. If you'll swear Mr. Sanders in, please.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
State your name for the record.
Edward Sanders, Jr.
Do you remember the motion that we're talking about that Mr. Shepard argued on your behalf?
Yes.
Was it denied?
Yes.
Based on this denial, what did you do?
Signed a plea.
Okay, and what were you sentenced to?
7 years.
Okay. Sometime later, you heard about Investigator Williams having some issues.
Yes.
And what was that you
credibility of the CIs and the cases that CIs have worked on.
Okay. Would you have accepted a plea had you known about these issues?
No.
Do you feel it would have been important for your attorney to know about these issues?
Absolutely.
And at the time of your plea, you did not know about these issues with Investigator Williams?
Correct.
And is it your wish that the judge vacate this sentence and start your case back up?
Yes, sir.
Well, that's all the questions I have for him.
Mr. Sullivan?
No question, Your Honor. Just argument.
Okay.
Just argument, Judge.
Mr. Bollinger?
Your Honor, as the state in their response, they cite Long versus State 183 Southern 2nd 342, and this is basically a two-pronged test for determining post-conviction claims when there's newly discovered evidence relating to guilty pleas. The first is the evidence must not have been known by the court, party, or counsel at the time of the plea. I think we've established that. And the defendant must demonstrate a reasonable probability that but for the newly discovered evidence, the defendant would not have pled and would have insisted on going to trial. And you look at a totality of the circumstances here. Mr. Sanders' whole case was based on this confidential informant and whether that confidential informant and the investigator was truthful. An attorney such as Mr. Shepard, I know, could have went to trial on this and did really good with people who are not being truthful on things and have messed up other cases. So we feel that, had the case proceeded to trial, the truthfulness of a witness would have been a major hurdle for the state to have overcome, and that Mr. Shepard could have exploited that. We feel that the Long test has been met, and we ask that the sentence be vacated and we be set on a pretrial conference date.
Mr. Sullivan?
Your Honor, I think it's important to note that the confidential informant in Mr. Sanders' case, as Mr. Shepard testified, was not the confidential informant that.
Let me just stop you for a moment. Would you have gone forward with this motion to suppress with this witness, knowing what you know now?
I don't know enough about the facts of Mr. Sanders.
That is a lawyer's way of saying, nope, I would not have, but I'm not going to throw an old colleague under the bus.
And the basis for the motion to suppress.
This wasn't your case when it was.
It was not, Your Honor. So I don't feel comfortable answering that because I don't know enough about the basis for the motion to suppress and the arguments that were made in the motion.
Well, let me ask you, you know enough about the witness now, not the confidential informant, but you know enough about the law enforcement officer.
Yes, Your Honor.
Would you have called him as your only witness in a motion to suppress, knowing what you know now?
No, Your Honor.
Okay. Would you have offered 7 years in prison?
Again, I don't.
I understand. That's not a fair question.
I can answer that. So out of the 10 cases that were vacated, I handled all 10 of them on resentencing.
And I'm aware of that.
And some of those cases we worked out new plea deals. There's one that I'm prepared to go to trial on moving forward, and I'm seeking 25 plus years on. So it really is fact dependent on the case and the circumstances and that particular officer's involvement in the case.
Okay. All right, go ahead. I'm sorry. I just want.
Your Honor, the particular CI that was used was not it was not the CI that Investigator Williams did not properly register. And the rationale, the basis for vacating those 10 sentences was not due to any credibility issues that Mr. Shepard claims that this officer has. The basis for vacating those 10 pleas was because there was a confidential informant that wasn't properly utilized. And our office felt that that was Brady material that should have been disclosed prior to any of those defendants using or entering pleas or going to trial. Our office was not aware of that information until after those sentences were, or those pleas were had, or those trials were concluded. So at that point, we felt that was Brady material that could have played a role in negotiations. That was the basis for vacating those sentences.
Yeah, that's more lawyer talk for we lost, we screwed the pooch, and we need to have something to hang our hat on. No, you have an officer that's lying under oath about, who knows what he was lying about. He doesn't even have a properly registered CI. So if he's not if the CI isn't properly registered and the officer is a pathological liar, the officer could have absolutely made up the CI. How do they even know that? No one knows who the CI is except for the prosecutor's office, and they're not releasing it. You have no idea. Of course they vacated the sentences and renegotiated them because, how? You have facts of a case built on a lying officer. I feel bad for all of them, every single one of them. The one that he was talking about, they're retrying it, he could get 25 years. There's facts of the case, But, all right, I'm going to let this video play out. This kind of stuff frustrates me, and Judge Clark is frustrated because this case, at least this particular one, was in front of him. So I think that's why he's frustrated about this. All right, I'm going to let it play out. Let me know what you guys think in the comments. Hopefully I can follow this case and see what happens to this guy. Hopefully. Judge Clark doesn't appear on YouTube every day, so I'm going to try. I will try.
The argument that this would have changed the defendant's position on taking a plea or not is tenuous, Judge. So if you take the defense argument that this officer has credibility issues because of an issue with this CI over here, moving forward with trial, that internal investigation involving that other CI would not be admissible in Mr. Sanders' trial because it does not involve that particular case. There's case law that is clear. Florida law is well settled that officers' internal affairs investigations are only relevant to the cases that those internal affairs investigations touch. So the fact that he had this CI that wasn't properly registered and misused that CI would not be admissible. It would not be relevant to Mr. Sanders' case, and it shouldn't be taken into consideration whether that would have affected his choice to move forward or not.
Okay. All right, anything else?
No, Your Honor.
I'll take it under advisement. We'll go ahead and Mr. Sanders will be transported back. If there's a change in that, we'll bring him back. Okay?
Thank you,
We won't
Judge.
set another court date until we have an order.
Thank you, Judge.
I see Dr. Dorico. I believe that's Dr. Dorico. It looks like him. And is he a witness on one of our motions today?
Yes, Your Honor. I believe it's Cody Brown.